Hi there. Due to the unintentional success of the previous non-molestation order video that I did, I thought it'd be I thought it'd be a good idea to do an updated video for the non-molestation order. It's been a year since I did the last one. It's done really well based on the fact that it's a non-molestation order video, which isn't the most exciting thing in the world, but it's done really well. In the last year, I hopefully got better at presenting, and hopefully my script writing has been better served. And this time I've got obviously my daughter who's helped me do the script in this one. In this instance, I'd like to thank my daughter who has helped me write this script for me to ensure that it's actually factually correct and accurate. And also, she believes that the script needs tweaking. Who am I to argue? Anyway, as we know, and if you don't know, then you're about to find out, navigating the family courts, especially when dealing with sensitive issues like non-molestation orders, it's challenging and often emotionally draining. This this monologue, script, whatever it is I've written, aims to shed light on this journey by elucidating the necessary steps required to efficiently traverse the intricate legal landscape. When a relationship has escalated to a level where one's safety is in jeopardy or feeling of fear are constant and evidenced by numerous stories of domestic abuse victims, a non-molestation order stands as a powerful legal instrument to protect the threatened individual. Courts grant this order to prevent a person from being violent, threatening violence, intimidating, harassing, or pestering someone they've associated with. It stands as an effective deterrent to and fosters a safer environment for the person at risk. However, understanding and navigating this complex labyrinth of family law to obtain a non-molestation order can be intimidating and stressful. There are also various procedures to be followed, paperwork to be submitted, and legal nuances to be understood. One needs to be equipped with the right information and tools to better comprehend the legal jargon and the protocol, which can often be overwhelming. This video seeks to demystify the journey through family courts for individuals seeking a non-molestation order, describing the comprehensive process, important steps to take, potential challenges, and the ultimate goal of receiving the protection that law can provide. By distilling this information into digestible elements, the overwhelming task at hand can be made more manageable, contributing to the easing of the stress associated with the legal world. Understanding the process of navigating family courts can be a daunting task, especially when dealing with matters as sensitive as non-molestation orders, a delicate subject deeply interwoven by personal safety and familiar family relationships. Approaching this topic requires the utmost sense of care and responsibility. The family court system holds a significant place in the justice system. It preserves the family structure while ensuring the collective rights and safety of its members. Key to this narrative are non-molestation orders, a critical protective measure instrumental in curbing domestic violence and abuse. Given the essence in averting harassing behaviours, non-molestation orders embody a beacon of hope for victims, reinforcing the integral role of the family court in not only resolving disputes, but also safeguarding the welfare of its constituents. Now, let me just pause you there. Given the essence in averting harassing behaviours, non-molestation orders embody a beacon of hope for victims, reinforcing the integral role of the family court in not only resolving disputes, but also safeguarding the welfare of the constituents. Now, granted, when it's being used effectively and it's needed to be used and it's being used in the way that it's supposed to be used, non-molestation orders are very effective and very useful tools to have, especially if you are dealing with an abusive man. However, there is a certain type of woman, a certain type of person, a certain type of character, he, him, they, she, her, he, them, whatever pronoun you want. Take gender away, and it's mainly women, let's be honest, but they are using non-molestation orders as a tool, as a weapon to alienate the father from the children. Now, I'm not saying that in every single case this is the case. I'm fully aware that it is not. But my daughter to write and reinforce this plastic jargon reinforcing the integral role of the family court as not only resolving disputes, well, I'm not being funny, but resolving disputes. I don't know any family that's gone into family court and family court have resolved the dispute. In fact, family court has generally made things worse, but the show must go on. This video will dissect the process of journeying through the family court system with specific emphasis on obtaining, enforcing and navigating the intricate dynamics of a non-molestation order. It will shine a light on the key procedures, legal requirements and implications of such orders, equipping readers with the knowledge and the awareness crucial in such sensitive situations. As we delve deeper into this important matter, we'll address the common challenges that often arise and the best strategies to handle them effectively. This discussion aims to illuminate not only the legal framework surrounding these orders, but also highlight the psychological and social impacts, promoting informed decision-making and facilitating a smoother journey through the often intimidating labyrinth of family courts. Navigating through family courts can be a daunting process, as I've said 3 or 4 times already in the first 3 or 4 paragraphs, which begins to helps us understand the primary function to adjudicate on family matters where resolution cannot be reached between the parties. Such matters encompass child access, financial arrangements, and issues of divorce and child custody. Preparation is crucial, and it commences with a filing of an application detailing your claim at the family court, where the parties are identified as either the applicant or the respondent. The applicant is the person making the application, the respondent is the person receiving the application. Legal representation plays a pointless role in family court. You do not need a family lawyer in family court. I don't care what the allegation is, I don't care what the situation might be, it's absolutely unnecessary, and what will happen if you get a solicitor in family court, no matter how bad the situation is, it will be made 100 times worse. They are snakes and only out for themselves and the money they can make for themselves. Granted, I do this, people pay me for work that I do, but I charge less than everyone else and I do a better job than everyone else because I actually fucking care. Simple as that. Now, they do say despite financial difficulties leading to reduced representation rate. No, it's not financial difficulties leading to reduced representation. It's the fact that only women who generally will get the legal aid because they will claim domestic abuse and domestic violence, and they use a non-molestation order as a tool to be able to do that. What they do is they'll get a non-molestation order, plead domestic violence, domestic abuse. They've got a solicitor then. They can then use the child arrangements. They can use the same solicitor for the non-molestation order all the way through the child arrangements as well, because it'll be publicly funded. You don't have to be Inspector Gadget to figure that out, do we, really? It's important to remember increasing numbers of self-represented parties indicate the importance of understanding the court process independently. Mediation and arbitration is often encouraged before a case proceeds to the family court to minimise family disruption and resolve issues amicably. Now, this is a great idea, but unfortunately, mediation doesn't work because there's not enough ramifications if the parties do not accept that they need to start as a starting point 50-50 equal, and if they can't do that for work commitments or whatever else, then they have to agree an alternative plan. If they can't agree an alternative plan, in my view, the child goes straight into foster care. People say it's too harsh, but we need something big because we need something to make people change, to make sure that when they end the relationships and they have children involved, that they are doing what's best for the child, what's best for themselves. And when they say family courts to minimise the disruption and resolve family issues amicably, there is not, again, one family case that I've been aware of that family court have aimed to minimise disruption and they've resolved the issues amicably. Very, very few. Now, if this path obviously isn't safe or isn't possible or safe, family court advisors, basically that's CAFCAS officers, will step in to provide a comprehensive safeguarding advice to the courts. So when mediation doesn't work, then CAFCAS step in and then they do a safeguarding letter to the court. Now that would not necessarily be through, and that will not happen with a non-molestation order. The safeguarding letter will happen when you are going through child arrangements, just so we're clear. Visit the CAFCAS website if you need more information, or just call me. The process is further broken down into stages of hearings and orders which are intended to prioritise the child's safety and the best interests throughout the proceedings. Now, again, forgive me, but it's not something that I'm aware of, that the courts do a very good job at that. They don't. As one goes through the family courts, several steps must be followed to ensure fair decision making. And it's not always fair, let's be honest. You get hatchet jobbed, you get surfed over, and it's part of proceedings. You have to be well behaved to make sure that you can get through this all of it. To initiate the process, one must file the application, obviously, to family court, detailing the parties involved in the case. The applicant is the individual introduced in the case. The respondent is the person against whom the case has been brought. It is crucial at this stage to secure legal advice and support, not in the measure of a solicitor, though, because they will just make things worse, as this methodically guides one through the court process and effectively articulates one's concerns. At this juncture, a court advisor will interview the adults in the application and supply safeguarding letters to the court which aid the decision making. Again, this is not for non-molestation hearings, this is for standard child arrangements. For non-molestation hearings, CAFCAS are not involved at this stage. If the case goes beyond the first hearing, the court may order a CAFCAS report requiring further separate interviews with the parents. That's known as the Section 7 report. At this stage, the court encourages the parties to resolve their disputes outside court through mediation unless it's unsafe. Now, mediation is not taken seriously at this stage with anything, and it should be. Mediation not only aids in the swift resolution of disputes, that doesn't, because people don't go there with the attitude of making it work, but it also improves long-term cooperation among the parties involved. No, it doesn't. Should an agreement not be reached, which it won't be, the first hearing dispute resolution appointment will help identify issues and assess the parties' capability of reaching an agreement. Generally, you can find out at this stage that you will not be reaching an agreement already, so it's pretty much a waste of an hour, and then you'll get directions off the back of that. Now, through this process, it's vital to remember that despite these steps, each family situation is unique and solutions are tailored to fit the family's circumstances. This is why nothing is ever the same, and you can't assess it to be the same because it's never going to be the same because no family is the same. Now, a non-molestation order, encompassed under Section 42 of the Family Law Act 1996, is a legal instrument designed to protect individuals from domestic violence, harassment or intimidation, whether the parties live in the same house or not. Now, the application process involves the use of an FL401 form, which can also be used to apply for an occupation order at the same time. This can be found on the government website, www.gov.uk/government/publications/apply for a non-molestation order or occupation order /FL401. Additionally, a free tool called CourtNav, run by Citizens Advice, can be utilised for this application to help and check if you qualify for legal aid. They love giving away legal aid, don't they? They love it. To provide immediate protection for yourself, the court may issue an interim order while the application is being processed. The length of the order typically ranges between 6 and 12 months, but can be extended if necessary. And let's be honest, ladies, if you really, really are nasty and you really are vicious, then you'll be going back to try and extend the non-molestation order. I know my ex-wife did and failed miserably multiple times. A non-molestation order can be prohibited a broad range of behaviours from the alleged abuser, and it must be said alleged, although it doesn't get treated if it's alleged, which include but not limited to physical violence, threats or indirect communication. The respondent must carefully adhere to the conditions of the order, otherwise you end up in prison, as a disregard to it is a criminal offence, and its alleged breach should be swiftly reported. And this is where men will have to keep their eyes open, because when you have a non-molestation order against you, if you have an undertaking put against you, if you have anything of this put against you, and you have a really crazy ex-partner, they will then see you walking 500 metres away, and then they can call the police and say, oh, he's just threatened me 500 metres away, he threatened me, he looked at me 500 metres away. They wouldn't say that. They'd say something else and exaggerate it, and then you'd get arrested. I have people who have been arrested, never been arrested before in their lives, never been arrested before ever in their lives, but then have had non-molestation orders put against them, and they've been arrested in excess of 30 times, 40 times. And that's because these people who have put these non-molestation orders in place, not all of them are scared, and not all of them deserve to be put in place. It's worth noting that an order can have a significant implication. These orders can have significant implications for the parties involved and may affect their ability to live a secure and contented life. Now, consequently, it's advisable to seek advice and support from an experienced Mackenzie friend to help gather the necessary evidence and information for the case. And automatically, it will give you the men's advice line, because generally it will be the men that are receiving the non-molestation orders, as it's a protective measure established under Section 42 of the Family Law Act 1996, specifically designed to safeguard individuals from various forms of abuse, including physical violence, threats, harassment, stalking, and indirect communication. This vital legal instrument serves to shield both the applicant and any relevant child from harm, and can be obtained against an abuser, irrespective of whether they cohabit with the applicant or not. Now, I would say this is where the women get a little bit trigger happy, because if they've split up with their partner, they can then use this non-molestation order as a tool to, quite rightly, as it points out in the script that's been so well written by my daughter, the vital instrument serves to shield both the applicant and any relevant information and any relevant child from harm, and can be obtained against any abuser, irrespective of whether they cohabit or have even done it, or if there's even any evidence or not. The detailed process of obtaining a non-molestation order entails the use of the FL 401 form, through which victims can articulate their experiences of abuse and request the imposition of a specific prohibitions upon the respondent. Those provisions might encompass restrictions on contact, approach, or intimidation with severe legal implications for breaching such mandates. Now, respondents facing the accusations typically navigate the proceedings as litigants in person, because the absence of legal aid, with personal service of injunctive orders being the norm. Now, upon application, courts may issue an interim order to protect the applicant while additional evidence is gathered. The court will subsequently issue a non-molestation order and/or the occupation order as needed, detailing the respondent's permitted time and forbidden behaviours. They will have time to go back to court and argue their point, and that's what you will do. You'll get a 15-minute, 30-minute hearing to argue your point and argue whether or not you agree or disagree with the allegations made. Now, if these allegations have been made after you've put a child arrangements application in, or as a result of a life event, i.e. she's got a new boyfriend, you've got a new girlfriend, you're getting married, new child on the way, some other life event, then you can pretty much, and she's trying to stop you from seeing your child, then you can pretty much guarantee that this is non-molestation will go this way. And they will be as difficult and as tricky as they can be. Your job is to try and get through the non-molestation order as quickly as possible, because it's a delay tactic. It is just a delay tactic. You have to either argue this point, and let's not forget, if you argue this point now in the non-molestation hearing, you will probably have to argue it again in the child arrangements hearing separately, because they run two separate cases. Your job is to try and get them combined. Sensible judges will combine a non-molestation order with a child arrangements order if you do not take an undertaking with no findings on the first hearing when you have the opportunity. You may want to argue your case and argue your defence and prove your innocence, and you will have the opportunity to do that. But at this stage, if you put a child arrangements application in and you're not seeing your child, the best thing to do for time is to take an undertaking with no findings and move forward swiftly with the child arrangements. The allegations that are being made against you will have to be heard later during the child arrangements hearing. Now, typically, orders can be granted for 6 to 12 months, yet they can be extended given certain circumstances. It's important to highlight that breaching the order is a criminal offence, and that can be enforced by legal action, underscoring the seriousness and the importance of the legal resources and victims of abuse. In summary, I would say navigating family court system, particularly when dealing with sensitive issues such as non-molestation orders, requires a clear understanding of the legal process that doesn't patience and due diligence. Yes, patience and due diligence. Yes, you need to have an understanding of the legal process and understanding that it's not ideal. It's not an ideal situation. It's not an ideal setup either. But hopefully, this small video, which has gone longer than what I expected it to, has outlined a few steps in the process, beginning with the initial filing of the non-molestation order. Next, it detailed the central role of evidence and supporting the claim, emphasising the importance of obtaining and presenting persuasive proof, such as medical records, photographs, or correspondence that substantiates any allegations of abuse. This video also highlighted the critical role of any legal representation and how they're shit, and they do not make anything any better in family court. They make it a lot worse. Navigating through family court and legal proceedings without a solicitor is my strongest, firmest, most biggest recommendation to you, full stop. This will give you the best chance for success, without a doubt. Furthermore, this video underscored, hopefully, the significance of the court hearing, where the respondent can challenge the application and undertaken if it needed be. Lastly, we discussed the enforcement of non-molestation orders, outlining the penalties for breaches and as part of the police in the role of the police in upholding these orders. Understanding this process is instrumental in dealing with family legal matters. A non-molestation order can have a profound impact, providing an essential legal safeguard for the vulnerable against further abuse. It's also a tool to use against the vulnerable, i.e. the men who have false allegations put against them. The family courts and the orders they issue play a vital role in our society in making sure men are broken and don't have a relationship with their children, a role that is best appreciated when we understand the intricacies, complexities, and its potential to protect individuals in dire circumstances. Thank you for watching this video. Hopefully it made some sense. Hopefully you smiled along the way. And hopefully, if you've got any other questions, you can reach out and give me a call. Peace and love.